Good afternoon, everyone. I'm Wade Kerrigan, a partner in Husch Blackwell's Intellectual Property and Corporate M&A and Securities Group. Wanted to thank everyone for joining us. When you're part of the IP group, there's always a chance of technical disaster. I'm aware that we are taking a bold move to go at the webinar with your panel in 6 completely different locations, and the chance that there'll be sirens outside my office. So I'm glad you joined one for hopefully some education today and the possibility of laughing at me. So I'm aware that both are distinct possibilities. But anyway, we're glad you're all here. Few housekeeping items first. I wanted to thank Emily Schumacher for getting us all set up today. Any mistakes made technically are my own and not Emily's. She did everything she could to make sure we had as few errors as possible. Few housekeeping items before we get started. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, submit via the question box down at the Q&A box. And please ask questions. I mean, we're all very exciting, or at least most of us are exciting. We would love questions, though. We don't really have a set script today. That's the point of a panel. So any Q&A we can engage in would be great. So please ask any questions you've got. We'd be happy to answer them. And we'll try to answer them all. But if there's a fuller answer you need, you can ask it via email or just ask it in this, and we'll get them and we'll answer them later via a more complete email. A PDF of the presentation will be available later in the resources folder. But just know we have pretty limited slides today because it's more of a panel setup. So if you're hoping for a 12-page due diligence checklist, you can find those online. This won't be the place for that here. This program has been approved for continuing legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. Certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your needs. Speaking of future programs, this is part of an IP seminar that we are doing. For those of you in Kansas City and St. Louis, you know that we have an annual seminar that we do, which obviously COVID wrecked. So this is the first of a few presentations we'll be doing. The next one will be March 16th at noon. Nathan O'Lean will be leading a panel on international patent and trademark issues, and we'll actually have guests from at least right now, I know, local counsel in Mexico and Canada talking through patent and trademark protection issues. So you all will receive invitation to that, but I wanted to note that will be the next seminar or webinar in the program to sort of make up for the fact we couldn't do all this locally. So anyway, that's all for the housekeeping items. So let's get started with our program. We have an excellent panel today combined of a client and a combination of corporate and intellectual property members of our firm. First off, and most importantly, Stephanie Schneider is a client and our guest panelist today. Stephanie, we're happy you're joining us. She's a principal at 5 Elms Capital, which also happens to be in our building here in Kansas City. She sits on the firm's investment committee, and she is a principal there. Prior to joining 5 Elms, she worked as an investment banker in Citigroup's technology group, where she advised both corporations and financial sponsors on mergers, acquisitions, and general corporate finance. Stephanie, thank you for being here. Jenny Witt is a senior associate in our corporate M&A and securities group here at Husch Blackwell in Kansas City as well. She has a diverse corporate practice and extensive experience in the areas of M&A, private equity financing, corporate restructuring, and general corporate matters. Ed Wilson is a partner in our corporate M&A and securities group and advises private fund clients on formation, regulatory, and investment matters. He has many private fund transactions involving software and other technology-based service businesses and significant experience in other buyers and sellers and other M&A transactions. Moving to the IP side, Max Ellenbecker is a senior associate in our IP group and counsels clients on patents, trademarks, copyrights, and trade secrets, and has extensive experience on M&A and venture capital support on the IP side. Liam Riley is also an associate in our IP group and works on many IP and technology matters for clients, including the same kinds of things that Max works on, in addition to a recent, more particular expertise around open source, which we'll be talking about later. So I wanted to thank you all for joining us today. without further ado, now that we're all done with the housekeeping, we'll kind of kick things off. Stephanie, we'll kind of start with you. I know typically in the role with Five Elms, you're in the situation of investigating a target company, for the possibility of an equity investment or maybe even a complete acquisition, although I think typically it's more an early on investment. Maybe interested in your thoughts about sort of your initial due diligence process, what you're looking at for a company, kind of more from the business side of things.
Yeah, absolutely. And happy to be joining everyone here today. I think from our perspective, whenever we're moving forward with evaluating a prospective partner for us to invest in, I think it's really important to, one, just first of all, build the relationship with the entrepreneur such that we would have a seat at the table when the time is right to partner with the business. Things that are really important to us as we look to kind of evaluate a business from a diligence perspective are a number of different items. Legal is certainly the last piece that we tend to cover off on. So many of these folks on the phone here have assisted us in many of our transactions. But I would say from a business perspective, there are several different things that we tend to key in and focus on, especially just given the state and stage of businesses that we invest in. So we're not partnering with businesses that are pre-revenue. These are businesses that are proven, that are roughly about 2 million in revenue, up to kind of 20 million in revenue when we first partner with them. So we spend probably a disproportionate amount of time understanding what their data shows. So we're highly metrics oriented, understanding which key metrics from software businesses are important for us, and can we get comfortable with what those look like based on our investment mandate. So we spend time kind of doing a financial and accounting diligence, but what's also important too, outside of getting to know the team and whether we're comfortable with those folks, is really getting a better handle on where the business is situated in a particular market, who their customers are, and how they ultimately differentiate from their competitors. So all of that takes place prior to us putting forward any sort of kind of initial term sheet or terms to a business. I would say that we, prior to issuing that term sheet, do spend time with the product and the engineering teams, making sure that we understand what the product offers and how customers interact and engage with that product. I'd say that a common phrase thrown around the office is we love to partner with businesses that have customers that are evangelical about the products that they offer. Ultimately, because that translates into a really sticky customer base that we're then able to validate from a financial metrics perspective. So all of that kind of happens prior to us issuing terms to a business, at which point we would then engage with some of the other folks here on this panel to make sure that we kind of get the proper legal advice in place at that point.
So how big is your business team typically that's working on? I know it probably varies depending on the situation, but how many folks at Five Elms do you use, and do you get outside consultants involved sometimes, Stephanie?
Yeah, so great question. From an investment team perspective, we have over 15 investment professionals that are doing more of the work that I discussed. But overall, we have 40 different professionals that are building relationships with entrepreneurs as well. So we're quite a large organization at this point. But from a specific deal team perspective, there's probably somewhere between 4 or 5 individuals that work on a deal that are doing all of this evaluation that I previously talked about. I would say where we likely get folks that maybe aren't involved in Five Elms involved outside of legal counsel and advice is largely around the technology piece. So none of us claim to be technology experts. We work with a technology consultant who advises us kind of on 5 really key areas. It helps us, or the consultant helps us evaluate the team that's currently in place, the processes and methodologies that are in place from the product and engineering perspective. They also help us evaluate and assess the infrastructure that the product and platform is built on. And then also helping us think through what that product roadmap needs to look like over the course of our investment, such that we're able to execute against that once we actually partner with them. And a lot of those results help us frame some of our conversations from a legal perspective of things to watch out for. So is the business built on an open source technology? What patents are in place? Is there any proprietary information that we need to be aware of and protect against as we look to really paper some of those more final transaction documents?
And do most of the target companies you're taking a look at, are they primarily in the technology area? Just the deals that you specifically work on? And really, I know for 5 Elms mostly, but I know you in particular. I mean, one of the reasons I'm so glad to have you here today is I know that's most, I think, of what you work on, right?
Yeah, so 5 Elms, all we do is partner with B2B software businesses. So everything we look at has some software or technology bent. So that really is why we work with you guys so closely to help us make sure that we're protected on that front.
Great. Now, I think it's important to note for this group, although not really part of the subject matter, that was, in fact, a dog sitting behind Stephanie who decided that the questions I was asking were so boring to bail out. So, Stephanie, I think it's important for us to know, what is the name of your dog before we move forward any further?
Her name is Bessie, and I'm sure she'll be back, but she might have decided she needed a potty break, so I'm sure she'll be back.
I immediately regret my first question that drove Bessie away so quickly. So Jenny, I know that before Max or Liam or I get involved in the transaction, it's usually Ed or you who will get the call from Stephanie or one of our other fine clients in a similar situation. And I know you work regularly with clients who are also, though, in the target company role. And when I use target company, I mean someone who's looking at receiving an investment or looking at being purchased. Can you tell me about that initial contact from a client who might be in the situation where a company like Stephanie's will be purchasing them and they've received perhaps a due diligence checklist from them or a term sheet or whatever stage they're at? Tell me a little bit about some of the things you're thinking about and worrying about as that happens.
Yes, I think from the target company perspective, we really look to partner with their team, and there's usually a couple people on the management team for a target company who really take ownership and lead due diligence from the company side. We partner with those point people to get organized at the outset to try to make diligence for the investor or the acquiring company as seamless and painless as possible, because that really, it greases the wheels for a smooth transaction in the substantive legal documents. If you're clean and you're organized on due diligence, the due diligence process, it usually starts with a multi-page request list that touches on a myriad of legal issues. And there will be particularly deep areas of focus depending on where the company's assets are. So in technology deals, you're going to see a disproportionate number of questions around the technology and the intellectual property assets. But for a company that has operations around the world, you're going to see a disproportionate number of questions dealing with international tax issues or things that might touch on the Foreign Corrupt Practices Act. You'll see more concentration in the diligence requests depending on the areas where the business works and where potential risk areas are. And our function in legal diligence helping target companies is to assess the diligence questions and help the point people at the company identify the subject matter experts in their own organization who can respond to those diligence requests. If they've been using us as counsel long-term, often we have a lot of their legal documents in our shop already. And so we really partner with those folks to populate a data room that covers all of the diligence requests so that then the investor or the acquiring company and their legal counsel can access this electronic data site, can get on the phone with the subject matter experts either at Husch Blackwell or at the company's office and get a better understanding of what the target company's business is, how they hold their assets, how they've documented them over time. And hopefully that's a really easy process because the company's been doing the right things all along, has all of the right documentation in place. But oftentimes we'll come up against areas where, for whatever reason, we're missing some key documentation or something wasn't done quite right historically. And so as the target company's counsel, we can step in to work with the investors counsel or the acquiring company's counsel and say, hey, we know that there's a deficiency here as far as legal documents go or as far as processes are concerned. this is what we would propose for dealing with this if it needs to be dealt with before the closing. So our role is to really partner with the target company and grease the skids to make the transaction go more easily so that diligence doesn't just take on a life of its own, because it definitely can if things haven't been managed and organized on the front end.
Great. And you know, amusingly, you talked about populating the data room. Ed Wilson and I remember when populating the data room meant carrying boxes of documents into a room. For those who don't work on these kinds of deals now, that usually means actually putting documents on a you know, cloud-based website somewhere. Although there are a few deals occasionally where, Jen, and I know you've had a recent deal where it was still actual documents sitting in a room somewhere, but that's in fact usually the case.
Yeah, my favorite story to tell starting associates is the time I got sent to Grand Rapids, Michigan to go to a data room, and I had to carry a chair behind me to prop open the doors because everybody else had left for the night, but I was there reviewing contracts in person. Wild.
How often, you know, as you're helping them through the, you know, the due diligence process with the target company, are you also maybe involved in helping them through the term sheet, or do you find, or the letter of intent, or whatever they're calling it at that point, or the memorandum of understanding, or do you find that that's typically been signed already in your experience?
You know, I would say it varies 50-50. It just kind of depends what the company's comfort level is with entering into those types of agreements. Oftentimes for a target company, if they are signing up for a takeover transaction, then usually we will have been involved with that negotiation of the letter of intent or term sheet. If it's taking on an outside investment, it just depends on the comfort level of the company. But I would say on the receiving end, on the target company end, more often than not, they would have involved us at that point. Yeah.
So, Stephanie, how do you decide when it's time to call Ed and Jenny and the rest of the team at Husch Blackwell? When do you start the due diligence process? When do you decide to get them involved? Typically, I know it can vary on the deals, but when do you decide it's time to you know, pick up the phone and have them walk down from the 9th floor down to the 7th floor?
It's typically when our hair is on fire, and I'm sure they'll both appreciate that, because I think whenever we reach out to engage them, it's always, hey, can we talk about this and turn this around in the next 10 minutes? But from our perspective, I think Jenny outlined this pretty accurately. It relatively varies in terms of when we involve them. Sometimes we will have fully negotiated an LOI, at which point we will reach out to them and say, hey, this is the LOI that we had signed up for, and would love to get you guys going from a legal and diligence perspective. Other times, especially if we're dealing with a little bit more complex of a transaction, we typically like to engage them sooner versus later, especially in a lot of the cross-border stuff that we are increasingly looking at these days, to make sure that we're thinking through all of the different bells and whistles that go into a term sheet and into those negotiations at the onset, to make sure that we're fully covered and feel comfortable standing behind the terms that we issue. Because I think something that's really important to us as Five Elms is that when we do put forward terms, we like to stand behind them, versus other circumstances and peers of ours oftentimes just present terms and then ultimately change them up on folks during the exclusivity period, in which case we actually believe that to be a poor way to start off a partnership. It often leaves a bad taste in folks' mouths. So we like to be as prepared as possible in doing so out of the gate. Sooner versus later is super important. But I think Jenny touched on this too. What that process typically looks like is they will assist us in the negotiation of the LOI, after which we will engage them and connect them with the management team of the target that we're looking to partner with, whether that's in a minority or a majority transaction, such that the management team can start working through that diligence request list that spans everything from business to technology to legal to all of these different aspects, to make sure that they have what they need in order to provide a comprehensive report to us, so that we can then paper the documents accordingly.
So you kind of mentioned, Stephanie, some of the business concerns you're sort of dealing with from the front end. And I know no deal is typical, but having, worked with you for a long time in other technology deals, what would you say are the sort of primary 2 or 3 legal issues you are running into in these kinds of transactions, if you could even say?
I would probably have to turn it over to Ed and Jenny. I don't know that there's necessarily any one thing that always kind of pops up. I'd say that more often than not, the biggest area that we typically get pushback on is really representations of warranties and understanding what provisions might exist in kind of the final legal documentation. So depending on whether you're taking a minority position or a majority position in a business, that can kind of vary in terms of the different protections that an institutional investor might be hyper focused on. And again, all of those different negotiations take a different form depending on what we have learned as part of the diligence that everyone on this phone assists us with. So if something stands out as, hey, this is a red flag, we're going to need to address this, we try to do that as quickly as possible. But sometimes there's quite a bit of back and forth in terms of the company pushing back to say, we don't believe this to be an issue and we would like to take X, Y, or Z stance. And we have to approach it from an investor perspective to make sure that we're confident and covered, depending on what we've uncovered during that time.
So we did get our first question, and thank you for the first question. And Stephanie, I have to guess this is directed at you. And the question is, how do you value a company that's just started getting traction? And I think you alluded to this a little bit. You're probably looking to see what the customer base looks like and everything else. And, I'm sure the multiples will vary, but, without putting out any of your, trade secrets for you guys, maybe a little more to, kind of some of the things you all look at.
No, absolutely. And I would make sure to caveat this with just in terms of how we as 5 Elms look at a business. So I mentioned this a little bit ago. We look at businesses that are doing at least 2 million in recurring revenue. So for us, if there is a new piece of the technology that is being rolled out, I think we have to be able to get comfortable with what exists today and how that might look going forward. So how we value businesses, that technology is only a component of that. I think other venture capital firms that are a little bit different than growth equity, they would take a look at the whole holistic market to say this new technology would be able to disrupt this market. And we would believe that the dollars that we're contributing to the business today will get the business to achieve X% of the market down the road. So I think that's one way that people could value technology within a particular business. I think for us, it's far more financially oriented and driven in how that particular business has scaled to the point in which we're evaluating it, and how much comfort can we get around the company's ability to really execute against its go-to-market strategy. So what has the sales and marketing team delivered by providing this technology and platform to its customers? Being able to understand what that flywheel effect looks like is ultimately what helps us kind of tie our valuation back to more of the financial metrics of a particular business. But that's not to say that we don't back businesses that like to iterate on their technology. That's very customary for us in terms of our partnerships. And we're comfortable understanding, hey, what does the technology look like today? What is in the pipeline from a product perspective? And how might that add incremental value from understanding pricing and what other competitors are offering in the market? All of that kind of goes into our thought process in terms of how we value a business.
Great. Thanks, Stephanie. So Ed, we've kind of talked to Jenny a little bit about how she looks at things from one side of things. How do you handle that initial phone call from Stephanie and other clients, sort of more in the acquisition mode? It's a little bit of it's some of the same kinds of issues, but a little bit of a different side of things when you're helping a company from the acquisition side of things.
Sure. So a lot of these transactions, Steph said we're only investing in SaaS businesses. So we have a pretty good feel for, the main garden variety M&A due diligence questions. But I always would talk to Steph or whoever else. Okay, what does this company do? Because if this company, has a bunch of stored individual, consumer data, well, that's definitely a different animal because of the privacy laws that are starting to get involved. Or as Steph mentioned, if this company has an international bend, whether they have international developers or employees or sales, that invokes a whole other set of due diligence issues. So understanding what the business actually does, how the technology works, is really important for us, so that we can, again, we can probably knock out 90% with a garden variety due diligence questionnaire, but getting those other kind of discrete issues for this particular business, it really helps to know exactly what they're doing. I think the other issue is just asking the business lead, like Steph, hey, what else is out there with this company? Again, Steph's probably been dealing with the company for weeks or months, maybe even longer. Sometimes their sales cycle can be really long. They meet a company, the company says, we don't want you. And you stay on them for a year, and then they all of a sudden need an investment. So understanding the history. So, one example, I think we had a recent deal. You look at a cap table, there's 7 investors. It seems innocuous enough. Well, Steph knows they've had a tumultuous past, and they've had people come in and people come out, and they've had institutional investors that got bought out, and squabbling family members or squabbling founders. So all those things are helpful for us to maybe focus our diligence on some issues that we wouldn't otherwise. We'd look at ownership, but we may not dig into, okay, we want to make sure, since these people were in a fight 3 years ago, we want to make sure this got cleaned up accurately.
Great. Thanks, Ed. And then, what point do you typically hear from clients, Ed, on the acquisition side? Do they get you involved before the term sheet and letter of intent stage, or is it after? I mean, I know it can vary, but tell me, and if there's any difference, from more of the straight M&A side versus the venture capital side.
Yeah, I'd say it's more and more it's earlier. Luckily, the clients I work with have done a really good job of getting us involved early. And I think that can solve, one of the problems Steph mentioned was you get into a deal and then the deal terms change. Well, sometimes that can be driven by how the company performs or a due diligence issue that pops up. But a lot of times that's driven by the fact that maybe the business people entered into a letter of intent, and just for whatever reason, there was some gap that was, that we didn't know about with respect to that business. And so catching that on the front end, maybe it's a tax planning issue. Maybe, the business is an S corp, and so we need to think about some tax planning or tax structuring issues. Maybe there's some other IP issue. Just knowing those things on the front end and tackling those up front, I think saves a lot of the headache. It saves the partnership between Steph and the company if we can tackle those up front and then have a smooth process where we're just doing diligence and we're just doing typical deal documents as opposed to renegotiating in the middle of the whole process.
Great. Thanks, Ed. We're going to move on over to the IP team. The calls come into the corporate department, and it's time to get the intellectual property group involved. Typically, when the firm is representing a company in this position of being the target company, our role is reduced in that situation. There may be some situations where we may be helping the target get things together. Usually our role is to receive the email that says, Max, could you get together the chart that shows all of our patents? Or Liam, could you put together the chart that shows all the trademarks we own? That's usually our signal that either our client is involved in a new bank financing, or it's looking at a big investment, or it's looking at a large M&A transaction. In those situations, we're going to help with schedules. There may be questions we'll answer on behalf of the client. And certainly we'll take a look at the purchase agreement and help negotiate the purchase agreement in whatever form it is, which we'll certainly be involved in on either side of things. But our role is much more reduced in those situations. So we'll be focusing more on the situation where we're representing Steph and Five Elms more and other companies that are in the acquisition process. So Max, when do you typically learn about a deal from the corporate team? What stage are you at when you find out about a deal?
Yeah, so typically Jenny or Ed or someone from our corporate team that's running the transaction will reach out to us once they've kind of started the initial due diligence process. Oftentimes, they receive some due diligence responses from the target company, and so we can look at those. But I think the most important things at the initial outset is they let us know what the type of the transaction is, whether it's going to just or a stock purchase or something, or a different type of transaction, and then just some general background on what the target company's business is, and if they know of any material IP issues that we want to be aware of. And that's really kind of at the initial stage. That helps guide kind of where we're going to focus on in our due diligence. If this is a consumer company or a product-oriented or technology-oriented company, we know we're going to focus a lot on IP assets and making sure that all the chain of title and ownership is properly aligned. If it's a software-based company, we know we have to look at several different issues, whether it's open source or customer data privacy, data security, all those different issues that are involved when you're dealing with software. But typically, they've already received some initial due diligence, and we can kind of help craft follow-up requests and get more information that we need to help work through the process.
Do you find, I know there's some situations where the due diligence checklist has gone out and maybe we've seen it, but do you find that in a lot of situations we might have to perhaps assist in further requests along those lines?
Yeah, typically, we see what's come back from the target in terms of the responses, and we have lots of follow up, and we can help, craft more targeted answers and questions to specific areas that we've identified. Traditionally, they have a good idea of asking the basic questions about, what's the material IP involved with the company? Are there material agreements that we need to look at? But, a lot of those kind of minute issues that can come up based on the nature of the business and what their responses are, we usually go back and forth with the corporate team and help kind of fill in those additional issues that we need to address.
Great. So I'm hoping this next part will bring Bessie back into the room. I don't know. There's a chance that discussing the nuts and bolts of some of the IP issues that we look at when it comes to diligence. I'm hoping so, Steph. So Max and Liam, I'm hoping this will work. But let's actually get into and we know a lot of you on the phone will think this is basic and elementary, and others of you will wonder why we're spending so much time on it. So there's always a balance when you start talking about the types of IP. But Max and Liam, I'll ask you guys to kind of walk through kind of these 4 basic types of intellectual property, and then obviously some of the areas that we look into as we're doing and thinking about due diligence.
Thanks, Wade. I can take the lead on the types of IP. So on the slide here, we've kind of laid out our 4 buckets of IP. Given the graphic, we have copyrights, trademarks, patents, and trade secrets. And each of those representing a pretty significant asset for companies that we're doing due diligence on from an IP and technology perspective. But each also have different elements. Some are registrable, some aren't. Some have varying terms, some have varying requirements with respect to contractual assignments and so on and so forth. But these are underlying a lot of what we're doing as part of our review, especially initially as we're going through initial requests and supplemental requests related to the due diligence. And then on the next slide, this would represent kind of some of our overarching questions as part of an initial due diligence request list. And to piggyback off what Max said earlier, our analysis is very focused and very specialized. So it's key that we have a contextual understanding of the target company as we kind of dig into this analysis. But in general, during the due diligence process, and kind of borrowing from what Jenny said earlier, we're really kind of breaking it down into assets and risks. So like we talked about on the previous slide, these can be identifiable, registrable assets. But a lot of times in these technology deals, these companies have assets that are intangible or maybe difficult to identify or appreciate. So really focusing on those unregistered IP are the ones that are more difficult to identify as well. And with respect to those assets, confirming ownership, there can be some nuance with respect to who developed it or created it and what kind of contractual limitations or arrangements they were in. and then checking for limitations and restrictions. And then, like much of the other aspects of due diligence, we're also considering the risk related to IP and technology. So that'll kind of include your standard litigation type risk as well as contractual limitations. But in the lens of IP and technology review, that includes specifically looking at IT type agreements to make sure that the services and assets are in place and that the company has the rights and obligations to continue with those IT related services. And then also on the risk side, we get some technology specific type risk that might pop up, which you've heard about today, including open source software issues and potentially data type issues as well. But if you look at our request list here, our example of it, there's 8 kind of general questions, and they fall more or less within those 2 general buckets of either being asset focused or kind of risk focused questions.
Yeah, I'll get to this next point in a second, but I'll preface it with this. As a young associate, the partner I worked with, told me to go write a memo when I was a first-year associate, and this will lead into Max and Liam, which the question is going to be for you all. What are the key areas and mistakes you find in your diligence with the target company? But I will preface it with this. The biggest is this memo I was asked to write. Under copyright law, I paid for it. Don't I own it? And my partner asked me to research that issue. And I went back and wrote him a 2-page memo. And when I found the answer, it seemed so obvious. I was like, why did he make me write this? If he didn't know the answer to this, I don't even know what to think. And I gave him the memo. He's like, yes, this is exactly correct. Now put this in your top desk drawer and never remove it. You're going to be shocked at how often this question is answered incorrectly by clients when you perform due diligence over the years. And I would say, as IP lawyers, I don't even want to guess the number of times we perform diligence and find that there is a target company that has hired somebody to draft source code for them or write a manual or whatever, and the document has failed to include some magic language. So I've given you both that setup, but there's other setups involved. And Liam, I will tell you, we've also had a question about copy left requirements, open source, that we'll ask you guys to address. So with that wide open question, start with the magic language question, as we call it in copyrights, and then maybe you all can talk about this is one of the main areas that I think really we want this webinar to address, is some of the big problems that you guys have seen, sort of in diligence over the last few years on M&A and venture capital transactions.
Yeah, so it's a very common issue that we usually flag, and it can sometimes be easily fixed, but sometimes it's more difficult. But particularly with software and other copyrightable works, lots of companies use independent contractors or developers to create that kind of IP, and you often see in those agreements that they don't include the required assignment of language. And so, the client or the target company doesn't actually have ownership in some of the IP that they believe they do or they're claiming that they do. Or if it's a license that they're receiving to background technology that's incorporated into something that was developed for them, are there specific restrictions on what they can do with the developed product or developed software that could have limits on what the target company can ultimately do with that IP. Other issues that I often have run into are, deficiencies in the chain of title with registered IP. One that we encounter is situations where there are liens or security interest on IP assets, whether it's patents or trademarks, that they didn't identify or they thought they had released previously that aren't and are still in existence. So, we can usually identify those during our searches during the due diligence process and hopefully get those cleared before closing of the transaction. Area I see has to do with employment agreements, and various states have certain restrictions and requirements for the assignment of inventions by employees. And a number of times I've run into situations where the target company didn't have the magic language that's required by their state statute to, effectively require employees to assign, certain types of IP that they create under their employment. And so, we just kind of flag those issues and try and gauge, how material they are to the transaction.
Great. All right. So we've been pretty successful so far, technology-wise. I'm daring to take it off the rails right now because I've asked Liam. I've set him up to talk about our favorite conversation, which is open source and particularly copyleft. But Liam, I'll let you decide how you want to answer that. But we have a poll. It's very exciting. So I'm going to keep this open for a bit and let y'all answer this question. Does your organization use open source software? And if you're a Husch Blackwell lawyer, I'll let you guess what the answer is. I know the answer to it, but I won't tell you what it is. So go ahead and answer and I'll show the results while Liam, you can talk. Take as much time as you want about this issue. This open source issue, Liam, I think literally the last 3 deals you and I have worked on here in the last few weeks have had this issue. So fire away.
Yeah, Wade, the open source software licensing issue has been kind of key in a couple deals, especially within the last year, which is interesting because before we had projects involving open source software, and then all of a sudden in 2020, several of the deals, it became kind of a key issue to consider and tease apart as part of it. And so by way of background, open source software is kind of trying to make software free and available for others because it typically source code falls under copyright protection, which is an automatic right that goes to the author. So to create this environment of kind of free availability of software, there's these varying licenses that attach to certain software, some of which are very permissive and kind of or basically just require an attribution notice to the original author. But others really try to reach downstream and restrict the ability of the subsequent user or developer from commercializing software that includes the source code or modifies the source code or links to the source code associated with kind of the free and open source software. And there's certain triggers to those restrictions, some that kind of your modern SaaS-based company may not run afoul of, but in certain instances could be an issue and could be a pretty thorny issue that's really worth kind of teasing apart. And because at the end of the day, the buyer and the seller want to avoid these issues as much as they can to make sure they understand what's going on. But I think kind of just to Wade's point, we're seeing a rise in these open source issues because I think in general, there's potentially a rise in the use of open source for probably a variety of reasons. But it wouldn't be surprising just because of the efficiencies of use. I mean, you don't have to go write this code. It's available and out there for you to use so long as you abide by the license. So that's kind of the background. I don't know if we want to see the results and everyone's candid answers. So almost a little over 2/3 of the recipients, the organization uses open source. And I think, again, there's a couple of things to point out. It's not necessarily problematic. As part of our review, we really are asking kind of threshold questions with respect to open source software to figure out, A, if it's been triggered, and then B, what kind of licenses apply and what kind of restrictions. And two, I think the Q&A question regarding copyleft, those are the ones called copyleft or viral that really reach downstream that can have significant impacts on the ability to commercialize the covered code or derivatives thereof. And so really trying to understand what licenses apply to what code, whether that code can be replaced, or whether the restrictions are even triggered are key to our analysis on open source software issues.
Yeah, and
right.
I think
Go ahead, Max.
One of the issues that we really are looking at is this used for internal kind of back-end systems that the target has developed that they're only using internally, or is this used for customer-facing platforms and software? And when it's the latter, that's when we really need to look into it closely and make sure that because they're commercializing this type of software, they're not going to run into any issues and restrictions about having that open source incorporated. So
Max and I talked about the problems that we run into, and Max, we've gotten a question from an IP attorney, which of course he's asked the question in a way that suggests he thinks only the IP lawyers can answer this. And actually, it's actually a dual question. So Jenny and Ed, feel free to jump in on this one. But the question is, do the IP attorneys have any input on how to address the situation when a security interest has been recorded at the Patent and Trademark Office and no record of release of those interests is filed, despite the fact that the loan/financing has been satisfied? So, Max, do you want to tell us a little story about the deal you and I worked on where a client told us not to run a security interest or lien search in Canada, and what we found when we ignored them and ran one anyway because yours truly is nervous?
Yeah, so this just happened recently where, we were assured by the target's counsel that, there was nothing to worry about with any security interest or any liens on trademarks that were registered in Canada. And, when you're dealing with other countries outside the U.S., we definitely want to look into those because we don't have as much visibility and familiarity with them. So we had our Canadian counsel do their own due diligence, and lo and behold, there was a lien still outstanding, recorded and the release was never recorded with the Canadian Trademark Office.
And the issue we run into there is if it's not recorded, it messes up the chain of title, both with the Canadian Trademark Office, and that's also the case in the United States. So, and the reason Jenny, as you and Ed know, Jenny, you might talk a little bit about this. Goes a little beyond the field of IP and IT, but you might talk a little bit about the UCC searches that we run on any transaction, because obviously it does have an effect on the diligence we're running. So you might talk about that a little bit for those, even those who are IP lawyers, because it does have an effect on our practice too.
Yes, I think that's really goes to the heart of the whole point of due diligence. So when I'm training first-year associates on what the purpose and how to think about due diligence, I think about, at least in an equity investment deal or a stock transaction, there are really two pillars, right? It's what's the value of the equity that you're buying and what's the value of the assets of the company. And so when you're trying to understand what the company is telling you as far as, how it owns its assets and its interest to those, we run UCC searches, and we have a capability of running broader searches even than just UCC filings to see if secured creditors have perfected their security interest on a company's assets by filing with their with the state where the entity is formed. So we can see if there are perfected security interests, and we can also see if there are certain types of litigation filed against a company, certain types of tax liens, all sorts of different, what we would call in legalese, encumbrances on the company's assets. And so that really, it goes to the heart of why we are doing due diligence, is to understand how the company owns its assets, and if the story that they've told us about its their assets and their value really holds up. And then the other pillar of that diligence inquiry is the ownership of the equity that the company would be issuing to our client if we're on the purchaser side. And so that is where we kick the tires on the company's capitalization table. And going back to what Ed was talking about earlier, if there's been a founder who exited the company in an unfriendly situation, or maybe somebody who was involved with the company early on and comes back later saying that they were promised 30% of the equity of the company. Those are all of the issues that we are trying to sort through in the diligence process, trying to really understand, is the equity that the company would issue to our client worth what we think it will be, and the assets, the value that they're bringing with their product, is that really, is that there?
Yeah, amusingly, Jenny, it was the corporate lawyer in me. I finally told Max that I was going to write off the cost. I found that it was bothering me so much that I was going to close a transaction without that search, that I couldn't take it anymore, and I would just write off the cost and explain it to the client, the partner who worked with that client more in one of our other offices, because I couldn't stand it anymore. And when it came through, I felt that my paranoia was justified. So another issue that we've run into a lot lately, Max and Liam, will be the subject of our next poll question. Yes, that's right. We have another one. And that involves data. So why don't you all talk about that one? But first, does your organization have an established policy regarding data, including ownership, licensing, or implementing proper protection relating to data? And I'll let you guys answer that question, kind of address that question of how we handle looking into data. And as you all know, not technically intellectual property, it's a contractual right.
I can take a first stab at this, and Max, feel free to chime in as you want. So data is kind of a hot topic, or is a hot topic currently, especially with respect to kind of data privacy. And I think as part of our review, we are aware of those, but then also know if an issue comes up or if a situation requires data privacy specialists, we'll get them involved on the key issues. But a lot of times where we might come in from an IP perspective, not necessarily a data privacy perspective, is to consider the ownership that a company has or potentially has in the data that they collect, use, or share, and really kind of understanding that. So to Wade's point, if we think back to the original 4 buckets that we showed, data just doesn't fall squarely within any single one or in any one bucket. And different parts of data and different aspects of data can fall in the various buckets, but really kind of understanding the data that a target has and what rights they may have in it, whether it's contractual or otherwise, is key to really kind of appreciating what value that might have and how that might be driving the transaction. And I think what's also key to consider with data is we've been seeing that a lot more. Data has increasing importance and values to companies. So a lot of times if data is involved, it typically requires additional investigation and analysis to kind of understand how it might be protected or what ownership or restrictions might be in place for the target.
Yeah, and when data is something that's prevalent in the deal and with the target company, often what we're looking at is, if there's agreements in place that they have with third parties or even customers, do they have the right to, under those agreements, to use the data in the way the target company is currently doing it, whether it's, creating data sets, aggregating that data. We want to look at those agreements and make sure the rights granted under those agreements align with how they're currently using it. And then the second is if it's a real customer facing platform or service where they're collecting data about their customers, making sure that their privacy policies are in place and that they're following and compliant with the way they describe their usage in those privacy policies.
All right, so let's see what we got here for the results. All right, excellent. And we did have a question to define data as we're using it. That came internally. We're running short on time, so we will we'll spare everyone the minutia of what we think of when we think of data. That could be that will run into a longer discussion, because I want to get back to Stephanie before we run out of time here. But one last thought to Max and Liam. I know that you probably have other key areas you've run into, but let's talk about now you've finished up your diligence. You've had your follow-up ads to the diligence request. How do you communicate that to Jenny and Ed and include it as part of a larger report that then is going to go back to Steph and her team? How do you do that?
Right. So like you said, Wade, our ultimate goal is to prepare a report for the corporate diligence team as well as the client that takes all this information, which is quite a bit, and distills it down into something usable, workable, that the parties can use to go back to the target or kind of, as Stephanie alluded to earlier, discussing reps and warranties and maybe adding some nuance or specificity there too. But really our report is to be clear, concise, understandable, identifying risk and potential effects thereof, as well as kind of action steps. I know Jenny will appreciate this because almost every diligence email she sends asks for us to identify items to spruce up. So a lot of our analysis will be to focus on things that may need to be fixed pre and post closing, but also identifying what actions the target company can take that align with kind of prevailing best practices.
Great. So Ed and Jenny, you've gotten the report from Liam and Max. They've done such a good job. It took me about 15 minutes to take a look at it and, make the one change I probably didn't need to make just so I felt like I was part of the team. You guys have gotten the report. I've taken a look at it, probably talked to Max and Liam about it. What are you looking at before you pass it along to Steph? And then what happens with that report?
So usually on technology deals like, investments in software companies or transactions where it's really an IP heavy deal, we've been working, real time, hand in hand with Liam, Max, and Wade and the rest of the IP team, even before the report is delivered, so that as issues come up in diligence, we are addressing those. We're, flagging those to the client early on. We're working with the company's counsel to, so that they're on notice that we have found an issue where we think something needs to get cleaned up. And so we take that report and I would say we use it in a couple different ways. So we're adding nuance or special indemnities or particular provisions to the purchase documents. And then we're also putting together the list that Liam alluded to, either things that we absolutely need to address prior to the closing, whether that's running down a key IP assignment or just making a risk assessment about if we can live without it. And then it's also putting together a list of post-closing items so that when the business person goes to the first board meeting after the closing, they're armed with an actionable and understandable list of items that need to be taken care of. And they actually, or our goal is for them to be armed with the knowledge of why that is important, so that it's not just, well, my fussy, nervous lawyer sent me this email and I feel obligated to talk about it.
Okay, Stephanie, the reports come back to you. What are you doing with it, and how are you handling it with your other principals and with your team, and what follow-up questions do you engage in, and kind of tell me what you do with it?
Yeah, absolutely. I think Jenny touched on a lot of it, but from our perspective, the deal team digests the big key takeaways from that report to say, hey, we need to escalate and elevate some of these items that will be a problem for us. Or we can say, hey, let's put a couple of these on the back burner. And as Jenny said, bring this list to our first board meeting to say, hey, these are the different items that we need to tackle within the first 30, 60, 90 days of our partnership, to say we will be comfortable once we put these in place. But having those action items certainly helps us assist the company with the proper actions that they need to take in order to be compliant on a whole number of different levels, whether it's making sure that there's domains registered in the proper company name, all the way through to securing proper insurance levels from our perspective. Appreciate that's not a technology point, but from our perspective, certainly a business point that is important. So I would say whenever we do uncover big kind of points that we might believe to be insurmountable as part of a deal, we escalate that internally to our investment committee. But typically whoever is championing that deal internally is one of the 6 members on our investment committee. So we have those conversations in real time in order to see if there might be a solution that we could offer and propose to get to a place where we would be comfortable and the team would be comfortable. But sometimes it's circumstances. The sooner you can tackle it, the better, especially if it's going to be something that ultimately blows up the deal.
Great, thank you. And it's funny you bring up, insurance issues, Stephanie. One of the issues we didn't really have a chance to get to is, the concept of cyber liability insurance is something that you all will look into.
Yep.
And I know we've talked about, I can't remember if it was last year's IP seminar in Kansas City or the year before. We had one of the folks we work with regularly here in Kansas City, who all named Brush Creek Partners, are great, and we've worked with them before. And we never would have even thought about that issue, 7 or 8 years ago. And now it's something we have to think about. And we won't get to our last poll question, although I guess if you want to answer it now, you can, is whether your organization has established information and data security policy. Answer while I'm going through the kind of closing here as we're almost wrapping up. So go ahead and answer if you've got time, but we'll see if we get to the results. But that's the last issue. If we'd had a little more time, we would have gotten into. But certainly making sure your organization has an information and data security policy. Stephanie, I know you'll look at disaster recovery and business continuity plans are a key part of the diligence that, we wouldn't even thought about years ago. That certainly has changed. So anyway, Stephanie, thank you for being with us today. Thank you to the rest of the panel as well. Appreciate Jenny and Ed and Liam and Max. Appreciate you guys being here. Thank you for everyone else for joining us today. This has been approved for CLE. So click on the icon at the bottom of the screen. Certificate of attendance will be mailed to you along with a recording of the webcast, which you can watch again. Bessie left. She never came back. I'm sorry about that. Please feel free to share the recording and complete the survey. And again, thanks everyone for joining. And let's see the results before we go. Oh, fantastic. Almost 93% of you have it. That's great. Thanks, everyone. Have a pleasant rest of your afternoon. Hopefully it's warmed up for everyone else. Take care.
Thank you.
Bye.